Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the Blazingame framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases. Yeah. Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
No, I understand that, okay. but putting that aside, the distinction between official act and private office seeker.
Yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder. Yeah. I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay. All right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in re-election.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of motive.
That's right.
Okay.
That is right.
All right, so then we're in the non-core powers where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And a
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, yes. but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with, at least in part, a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
all right, intentions. I mean, you can frame a motive as an intention, and intention as a motive, as you well know, every day of the week. So let's put that aside.
I understand. Well, putting that aside, that really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable, and others that aren't. I mean, it's awkward, right? When we look back at like the injunction, back to Marbury in the early cases, you can't enjoin a president. Also meant you couldn't hold him in contempt. Right?
A sitting president.
For sure.
Justice Gorsuch, can I try one more time?
Well, let me just spin this out just a second, right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts?
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and then seeing what restrictions they do place on the president's conduct. And, for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512c2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Okay. Thank you, Mr. Dreeben.